So, hi everyone. Thank you for joining us for today's Facebook Live. I'm here with Michelle Kinney of Cassels Murray. She's here to talk with us about third-party reproduction and fertility law in Canada with a very catchy title, Who is a Parent? As you know, Fertility Matters is a not-for-profit organization and we rely heavily on support from the public. So if you can and are apt to do so, please visit the Fertility Matters Canada webpage and click the donate button if you can. And all week long, we've brought you awesome content from various professionals in the field, including REs, financial planners, et cetera, et cetera. So please check out the Fertility Matters Facebook page and watch those archived videos if you haven't had a chance to see them live. So Michelle, would you like to take us away?
Sure, I would love to. Thank you. Hello, everybody. I'm really excited to be here today. I am a fertility lawyer in British Columbia, and I'm part of a small group of fertility lawyers here called Fertility Law BC, and we are members of Fertility Matters. I'm really excited to be here to talk with you today. What we're going to do is essentially a crash course on the laws in Canada that apply to people using assisted reproduction, in particular people who are using assisted reproduction who need a third party assistance. So need a sperm donor, egg donors, surrogacies, for example, or who have alternative family structures, and how the law applies to those families. I do have a PowerPoint here. The law is fairly dense, so I have done slides. I'm not sure if they can be shared or not later, but I am fine with those being shared if needed. I will be breezing through some parts of the law, and I am assuming that most of the listeners here are fertility users and maybe don't know that much about the legal scheme behind the assisted reproduction. And so I'm taking that approach to this presentation. And I'm sorry if I have any, technology issues. This is my first time doing a Zoom presentation. I did just lose my screen for a second there, but I'm back on track. Okay, so as I said, we're going to be talking about the law that applies to you, and there's two types of laws in Canada that apply to people using assisted reproduction. The first are the federal laws, and then that applies to everyone across Canada. And then there are provincial laws. So those laws apply depending on which province or territory you live in. And those laws define who is a parent where assisted reproduction is used. So we'll go through both of those schemes. So first, just to make sure we're all on the same page about what we're talking about, when I use the terms assisted reproduction in a legal way, I'm talking about assisted reproduction means any method of conceiving a child other than by sexual intercourse. And assisted reproductive technologies include donor insemination, IVF, IUI, surrogacy, the whole gamut. So we're going to start with the federal scheme. So the Federal Assisted Human Reproduction Act is the law in Canada that applies all across Canada to everyone in Canada. It's been in place since 2004. And it prohibits certain activities. So it prohibits people from doing human cloning. It also prohibits the payment for genetic material and surrogacy services. So what that means is it prohibits, you cannot pay for sperm here, you cannot pay for donated eggs here, and you cannot pay a surrogate for her services or for her time. The Assisted Human Reproduction Act does not deal with the legal status of who is a parent where assisted reproduction is used. That is done through the provincial laws and territorial laws, which we'll talk about later. So what is prohibited? You cannot purchase, advertise, or pay for genetic materials such as sperm, eggs, or embryos. You cannot pay for surrogacy services. You can't pay for anyone to arrange surrogacy services or advertise such services. You cannot use the genetic material, so a person's sperm, for example, without the written consent of that person. And you cannot use sperm or eggs or genetic material from a minor, from someone under 18. And the penalties for breaching these prohibitions are severe. So a breach of most of these, it's a criminal offense and is punishable by a maximum fine of $500,000 and or 10 years in prison. So this is a significant penalty. It's a bigger penalty than many things that I would say might be of more potential harm. So it is important to know what you can and cannot do, because it is illegal, for example, to pay a surrogate, and the penalties can be quite significant. There has only been one case that has where this prohibition has been applied, and there have been no intended parents, for example, who've been charged, but you can be charged. The law is there. The Assisted Human Reproduction Act, the biggest thing about it is the reimbursement and the expenses provisions. So the Act itself does allow you to reimburse reasonable expenses incurred by a surrogate or donor. So you can't pay for their services, but you can pay for reasonable expenses, such as anything, I call it the but-for kind of. But for the pregnancy, you would have or wouldn't have incurred this expense. And if you have new expenses because of the pregnancy, if you're a surrogate, for example, you can claim those expenses and the intended parents can legitimately pay for those expenses. Up until now, there has been no real rule about what counts as an expense that can be reimbursed and what doesn't count. And it has been a fairly flexible approach that has been at times used creatively or restrictively. That is about to change. And the federal government has brought in regulations around expenses, and they are set to come into force on June 9th, 2020. So right around the corner now. And these regulations will limit and define what expenses may be reimbursed in both a donor situation as well as in a surrogacy situation. And the rules are a little different for those two situations. Namely, because when you're talking about a donor, you're talking about usually a one-off situation. Egg donation's more fulsome of a process than sperm donation, but a surrogacy is essentially a year-long process. So you need to have some differences in the regulations for that. It also requires specific processes in order to claim reimbursement. So from here on in, starting after June 9th, a surrogate will have to have receipts for every expense, list those, and then sign a declaration swearing that those were the expenses that she incurred, and the intended parents will have to sign that as well before payment can be made to the surrogate. Some of these expenses will now require a medical practitioner to prescribe those, including things like lost wages. So if the surrogate needs to be off work, because of appointments, because she's on bed rest, that has to be at the doctor's orders. The surrogate can claim lost wages, but only with doctor's confirmation. And there is a bit of a gap in the sense that there is no lost wages provisions at this time in these new regulations for sperm or egg donors. The regulations also say that the intended parents must retain the records for 6 years. I personally think these reimbursement regulations went too far and don't hit the balance properly. I do think that we needed more guidance on the issue of expenses. However, I think that this is going to create a fairly onerous process and is going to create a situation where it's going to be more challenging for surrogates to get expenses back. And I do find that to be, in my own personal opinion, I have a hard time with that because a surrogate is giving a year of their life and their health and their future possible health in order to help somebody have a child. And it is my personal view that they should never be out of pocket. And I am concerned that some of the limits within these new regulations may cause some challenges to reimburse even legitimate expenses. So we will see if some of that gets worked out in the wash. But those do come into effect June 9th. And if you are paying or claiming expenses, you will need to comply with these regulations, or it will be against the law. There's also new known donor regulations, and these are good news ones, I would say. They came into effect on February 4th, 2020, and they make it easier to use a known donor. Previously, it was very hard in Canada to use a known donor because you had to have the sperm quarantined for 6 months, and the only sperm cleaning facility, I'll call it, was in Ontario. And so if you were in BC and your friend was prepared to donate sperm to you, they would have had to fly to Ontario, have their sperm quarantined for 6 months, only after that could you use it. So it was hard. It was hard for you to have a known donor, and you would end up often having to just use sperm banks. The interesting thing about Canada's prohibitions on payment is that you can't, for example, pay for a sperm donor here or pay for sperm here in Canada, but you can still order sperm from the States, pay for it, and have it sent to a clinic and use it in Canada. That, in fact, is not illegal. And because of Canada's rules around the prohibition on payment, and up until now, the known how they've approached known donors, there's a sperm shortage in Canada. So hopefully this known donor regulation will make it a little bit easier for people to use sperm donors that they know, and that may make the process easier and more affordable. We can hope. There has been, I feel like we're at the tipping point with respect to assisted reproduction issues. The regulations, I would say kind of came out of the blue in 2019 after many, many years of nothing happening on the Assisted Human Reproduction Act or the laws around that. And so the regulations all came down, and then around the same time, on the flip side, in 2018, federal MP Anthony Housefort, that is the wrong name, introduced a private member bill to amend the Assisted Human Reproduction Act to decriminalize payment for sperm and egg donation and for surrogacy. It didn't go forward, it died. However, I understand there are continued talks in government, and I do think it started that process, and I think that is an exciting conversation for us to be having at this time. So now I'm going to move on to sort of the more provincial regime. So we know now what you can and can't do under the federal law, but what about then when we get down into the crux of the other side of the law? Who is a parent, and how do you define that? Previously, there was a real gap in the law, and the lack of legislation in Canada respecting legal, like who was a parent, where assisted reproduction was used, was really creating a gap in the law and a lack of, it was unpredictable what would happen in certain situations. So case law was filling this void on an ad hoc basis. And up until 2013, when the BC family law came in, the legislation across Canada all assumed essentially that all children are conceived through sexual intercourse, and every child has a mother and father, and then anything outside of that was treated in a piecemeal way. So I would say BC led the pack, and Ontario has jumped on board. And at this point, BC and Ontario are really leading the pack in Canada with respect to assisted reproduction, I would say. BC was the first province to enact a comprehensive parentage regime, which addresses who is a parent, where assisted reproduction is used, and that came into force in 2013. And then in 2017, the Ontario All Families Are Equal Act came into force, and it, in this regard, generally followed BC's approach with respect to assisted reproduction and parentage, although there are some differences, and we'll talk a little bit about those as we go through. Significantly, both provinces now have what I'm calling an administrative regime to register a child, including in a surrogacy situation. So that means that parties who meet certain requirements and take certain steps in an assisted reproduction situation, such as surrogacy, do not need to go to court to get a court declaration or adopt their own child, for example. You can, as long as you've done the correct steps, you can file the proper paperwork with the Vital Statistics Agency or the registration agency, and the intended parents, the people who are supposed to be intended to be the parents, will be the parents on that birth certificate, and the surrogate will not be. Up until now, and in every other province, you still need to have a court order in order to be named parents on a birth certificate in a surrogacy situation.
Michelle, can I interrupt with a quick question?
Yes.
So BC and Ontario are leading the pack, which is great if you live in BC and Ontario. If you don't, are there rumblings about changing the provincial legislation to be more aligned?
I think so. I think that BC and Ontario have really started a trend, and there's been a number of provinces that have looked at amending their legislation, have done work on it. It hasn't quite happened yet, but I think it's moving that way. And I will talk a little bit about what is happening in other provinces. I'm going to go through and chat a bit more about the scheme in BC and Ontario, because I think that's where a lot of the
Right.
third-party assisted reproduction is happening. And I think that over time, the other provinces and territories will go that way too. And then we'll talk about a little bit of the differences in other places.
If you live in a province that's not BC and Ontario, and you say did your assisted reproductive work in one of those provinces, which laws would apply?
The law where the baby is born.
Okay.
So, I mean, I usually say to people, you want your baby to be born in BC or Ontario. So why is legal parentage important? Why do these laws matter? And I would say it's really important because it establishes a child's identity, their family name, their heritage. It determines their inheritance rights and legal obligations of the parents. Because of the new laws in BC and Ontario, the intention to parent has now become more important than the genetic connection to the child in determining who is a legal parent. I think that's pretty cool. Because it has, up until then, it's always been, who is genetically connected to the child, and that should be the most important. Really now, it's about who meant to be that child's parents, and that is how the law is flowing in BC and Ontario. So I just have some key terms here. When I'm talking about terms, the birth mother, birth parent is the person who gives birth to the child, whether it's from their eggs or not. The donor can be a sperm or egg donor, as long as they're donating it to someone else's, for someone else's reproductive purposes, for someone else to have a baby. And then when I say the intended parents, and I've already used that term, like I said, I'm talking about the people who actually intend to be the parents, whether or not their sperm or eggs or genetic material are being used. Across Canada, the general rule is if you have a child through sexual intercourse, the parents are the birth mom and the biological father. That's the rule. So there is one small carve out of that, because in Ontario, their new law did carve out that it's possible to be a sperm donor through sexual intercourse under certain circumstances and where there was an agreement before the event happened. But in BC, that's the bright line. If you have a child through sexual intercourse, the assisted reproduction regime does not apply to you around parentage. The two people who had sex are the parents, and you cannot opt out of being a parent under those situations. And I call that that's a daddy, not a donor rule.
We have to hashtag that.
Where the general rule where assisted reproduction is used is the birth mother or the birth parent is a parent, and then that person's partner is the other parent if they have a partner. So it doesn't matter how long they've been in a relationship. It doesn't matter the gender of the other parent. It is presumed that if the birth mother's in a relationship with another adult, that is the other parent, unless that person did not consent to being a parent or withdrew their consent before the child was conceived. The general rules around donors is they are not parents. At least in BC and Ontario, that is very, very clear under the law. A donor is not a parent. You can't go after a donor later because of genetic connection for child support, for example. They are not a parent. I did have a question here about, if you're thinking about using a known donor, do you need a donor agreement? And I would say, in BC and Ontario, the law is there to protect you. So it's pretty clear the donor isn't the parent. So it does protect you in that sense. Nevertheless, I still think that whenever you're using a known donor, you should get a donor agreement before the donation happens and before conception happens, for clarity. If you're not in BC or Ontario, I think it's essential because you want to make sure that your intention was clear. But like I said, even in BC and Ontario where the law is clear, I still think it's always a good idea to have a written agreement in place before a sperm or egg donation. In surrogacy, that's a situation where the intended parents are going to be the parents. So let's assume it's a couple, and they need the assistance of a woman to carry the child for them, but nobody is intending that person to be a parent. In that kind of situation, you need to have a written agreement in advance, so before conception happens, that all parties sign off on, saying that the birth mother will not be a parent, she will surrender the child to the intended parents, and the intended parents will be the parents of the child. But that's not all you need in a surrogacy. In a surrogacy, you need to go an extra step. And after the child is born, the intended parents must take the child into their care, and the surrogate must consent to relinquishing the child to the intended parents. So that has to happen after the birth. And then assuming those two steps have happened, then you can just register the intended parents can register the child as their child with Vital Statistics Agency, and they will be named on the birth certificate. So it's a nice streamlined process, nice clear streamlined process in BC. In Ontario, they have a very similar process, except there are a few differences. In Ontario, you have to wait 7 days before the surrogate signs off on relinquishing the child. There's a little waiting period. Independent legal advice is required for surrogacy agreements, so they must have talked to a lawyer. In BC, that's not a requirement, although it is, of course, encouraged. And what we talked about earlier, sperm donation can, in some situations, be provided through sexual intercourse, as long as there was a written agreement in advance. And in Ontario, they do specify that you can have additional parents. So in a surrogacy situation, you can have up to 4 parents. And if you wanted to try to have more than 4 legal parents, and I'm talking legal parents, like who is on a birth certificate, for example, and who has inheritance rights, etc., you would have to do that by court order if you needed more than 4, but the law specifies that there can be up to 4 parents in a surrogacy situation in Ontario. BC does
sorry.
allow. Sorry, Michelle.
Can we go back a slide? I have a couple of questions.
Okay. That one?
Yeah, you did it. Great. So the 7-day waiting period, what's the purpose of that?
Well, I don't really feel like I can speak on the intentions behind the Ontario law, as I know the BC law well. I don't know. That was one of the things that concerned me about the Ontario law. I think it was in order to make sure everybody knew what they were signing off on. So I don't really feel like I can quite speak to that.
Okay. And then there's a question from a viewer, which is, can a clinic require a donor agreement to proceed with IVF? Do they have that power to require that a patient needs a legal agreement with the known sperm donor, even if they're protected under BC's Family Law Act?
Well, I think that the clinics can define what they feel like they need in order to proceed. I have seen clinics say, I need this agreement. Sometimes there has been situations where they haven't needed them. Other times I have had clients say, oh, well, actually, I was told by the clinic I need to have an agreement in place, and that they would need to have heard from a lawyer that there is an agreement in place. It's not a requirement under the law, but if the clinic requires it, I don't think that there is a legal issue with that.
Okay. I'm done.
BC does allow for additional parents too. So if you think, I'm talking about families who are looking at using assisted reproduction to create more alternative families. So the most common, I would say, is the example of, say, a gay male couple wants to have a child, and their female friend has said that they'd be happy to carry the child, but all 3 of them want to parent together. That's allowed in BC, and I would say in Ontario too, likely. And all three of those people can then be on the birth certificate. The other alternative is the lesbian couple and their male friend who would be providing sperm. All three want to be a family. You can do that. And there are a few three-parent families in BC now. There are some certain situations where it could extend beyond 3, but I don't know why anybody would want to do that. But you also then would have to, I think, have a court order in order to get everyone on the birth certificate, and there'd have to be a pretty good reason.
My guess is that it would help with childcare.
Well, the other side of my job is separations and divorce, and I just think about sharing parents. Like a 5-parent family sounds like a nightmare, but you know. Yeah. I'm not going to get into this because this is a big topic all in its own, but there are ways that a person can become a parent of a child after their death. So that situation would be where they have provided, say, I'm going to use sperm as an example, before their death, maybe because they know they have cancer and they are not going to live. They provide their partner consent in writing that they can use that sperm after their death and that they would be a parent of that child after their death. And in that kind of case, that is possible. So here's just a little a BC Ontario parentage cheat sheet about those sort of rules, summarizing those. So I'm not going to go over all those, but it summarizes what we just talked about in a handy little sheet. And then we're going to just briefly talk about other provinces, because all the other provinces and territories are different and the rules change depending on which province you are in. The rules change on everything, how fast it takes, what counts, what doesn't. So we'll talk a little bit briefly about some specifics. Alberta and Nova Scotia, next to BC and Ontario, are probably the clearest. They both have some legislation around it, not a clear scheme like BC and Ontario, but they do have some legislation around it. And in both of those places at this point, the general rules are there's only 2-parent families are allowed. There must be a genetic connection. So one of the intended parents must have a genetic connection. So it must be the male's sperm or the female's egg, for example. You'd need to do a court application in order to remove the surrogate from the birth certificate and have the intended parents be the parents on the birth certificate. It is same-sex friendly, so it does apply to, same-sex couples can be on the birth certificates for a child. But you do need to go through a court process. Quebec is very unique in Canada in the sense that surrogacy is not recognized in Quebec. So actually, in fact, in my surrogacy agreements, we usually spell out travel restrictions as, you get further on in the pregnancy because you're trying to have the baby be born, say in BC, where the law is clear. And at some point, I usually would put in, at a certain stage in pregnancy, you can't travel internationally or to Quebec. Because if the baby were born in Quebec, your surrogacy agreement is moot. The surrogate will be the parent there until you go through an adoption process. So Quebec is unique in that way, and it's the only province that does that. The other provinces and territories don't have a specific legislative scheme. So this means that it's unpredictable. If you're in one of these other provinces and territories and you're going to be doing a surrogacy, or you're going to be using a known donor, you should seek legal advice in the province that you're at to make sure that you understand the risks, you understand the processes, you're sure that you can meet your objectives through the law. And in all of those situations, you probably want to have a situation where one of the parties, like one of the intended parents, has a genetic connection to the pregnancy to avoid unpredictable results. I'm just going to end on this, sort of looking forward. The area of fertility law and assisted reproduction in Canada is very live right now. I think, like I said earlier, I think we're at a tipping point. The people needing to use assisted reproduction are increasing. Infertility issues are increasing. More and more people are needing the services of assisted reproduction. And so I think more and more these issues are going to start to become live issues for the average public, for government. And I think we're going to start to see a look at some of these issues, and hopefully over time we'll end up getting a more uniform situation across Canada with respect to how the laws are applied and how parents are determined. And hopefully we'll deal with some of the questions around sperm and egg shortages. I think the biggest issue at this point, the next biggest debate, is going to be about whether Canada should be changing its rules around compensation to sperm donors, egg donors, surrogates, if those rules should change. I think that's going to be, there's going to be a real key push around that and a lot of debate around that. Other than that, I think I just had some resources at the end, a link to our Fertility Law BC group's website. I also provided a link here to the Government of Canada website around assisted human reproduction. And on that site, there are the Act, the regulations, guidance documents. So if you are a user and this just strike fear in your heart because you're like, oh my gosh, am I paying for the wrong things? And I need to see what the law is. There, you can look there. All the documents from the government are up on that website. I think that's
wonderful. So we have some questions. We have some questions coming in. We encourage everyone to just post their questions in the comments of the Facebook live chat. I know from experience that when we start talking about donors of any kind or third party, we tend to get very quiet. So if there's a way for you to email your questions or anything like that, that would be great. If you don't want your name popping up, but just get your questions to us somehow, and I'm sure we will end up having Michelle or one of your colleagues back another day as well, and maybe we can answer more questions then too. So one of the questions that has come in is, I'm wondering about sperm donation from a sperm bank. The sperm bank I'm using gets sperm donors internationally. Does this change anything in the law for me, and I'm residing in Ontario?
No, that's legal. You can, yep, you can, if you end up buying from a sperm bank that's international or in the States and having it sent to you or to your clinic, that is legal. You just can't do it within Canada. You can't pay for a sperm donor within Canada, and so we don't have those kinds of big sperm banks here in the same kind of way.
Okay. Regarding surrogacy, what rights has the surrogate if they change their mind? Are they obligated to concede their parental rights?
Oh, that's a tricky question. No, because the first agreement, the surrogacy agreement itself, isn't legally binding in the sense that it cannot force someone to hand the child over at the end. That's why you need to do the second step after the baby is born. However, I would say if that were to happen, you'd end up in a court case, and at which time generally the agreements that you signed would be able to be put between the court to determine what the parties' intentions were. And at that point, you're in a court battle about the child, where the best interest of the child will end up being the thing the court needs to look at. So they'd have to be balancing best interest of the child, the family they were supposed to be part of, the reasons why the surrogate is not handing the child over, what the actual agreement was and what the intention of the parties were. And that's a very complicated situation. And I suspect at that point, usually in the surrogacy agreements, there's things about if one party breaches the agreement and doesn't carry it out, there might be a clause, for example, that the surrogate would have to repay back the expenses, etc. So there might be a deterrent kind of factor to it as well. The reality is, it almost never happens. The people who go in to be surrogates have generally thought through this process and really are doing it because they want to help somebody have a child. And if there's any question that is from the surrogate side that is her intention, she probably shouldn't be doing surrogacy. It is, everybody really goes into it with their eyes open and should go into it with their eyes open. And as a result, these agreements actually remarkably, like I have not yet have her even like there's just not situations where it happens. The surrogate generally does what she's supposed to do, hands the baby over, everyone is delighted, and of course there are some issues and some struggles, but it doesn't happen as much as people would think it would happen, that these things fall apart.
The new regulations, do the directed donation regulations apply for sperm in a surrogacy scenario?
So, sorry, can you read that again?
Do the directed donation regulations apply for sperm in a surrogacy scenario?
I think they would. I mean, again, they're pretty new, and they haven't, so they're all just getting fleshed out too. But my understanding would be if you have a known donor, and it's going to be, I have to think through this. I think it would. I think it still would. I don't think I can 100% answer that question. It's a pretty discrete question, and I think it's a little more complicated than can be answered in a sentence or two. But I believe so. I think, the clinics at this point are hashing out how the known donor things are going to work, because the clinics are really going to be the gatekeepers, probably of how these are applied and where they are, and they really haven't had a chance to flesh any of that out, essentially because those regulations around the known donors only came in February, and then basically everything has shut down because of COVID. So I think a lot of those questions and answers will really flesh out as the regulations become practice and policies are developed around it. I don't think I can answer that question at this point, though.
Okay. You're a lawyer, obviously. At what point should someone who's considering third-party reproduction engage a lawyer to be involved?
I think the earlier the better, because just because you engage a lawyer to be involved doesn't actually mean you have to start the process. But I think it's important to get legal advice early. I do find a lot of times people come to the lawyers a little too late, like they're already all the way through the clinic process. They're, everything's been approved. They have their dates, and then they're like, oh, now we need an agreement. It needs to be done in a week and a half because that's our new date, our date, And then you're like, oh, geez, and what have you guys talked about? And so I think actually the earlier the better. At least to get some advice, and then because usually you can just get some advice and then be like, okay, well, I'll let you know once the surrogate is confirmed or they've done their tests, and then it can happen in a little more coordinated manner. So I'd say earlier, but the earlier the better. Yeah.
In your practice, do you find that the laws that exist in BC or Ontario, do they discourage some people from pursuing third-party reproduction?
The laws in BC and Ontario? No, I think that BC and Ontario make it easier than everywhere else. I think it's the easiest in BC and Ontario to proceed.
Great. We talked a little bit about some of the provincial laws being a little outdated in our opinions. What can the public do to help advance laws?
Write your politicians. Let them know that this is an issue and why it's important to you and other people. I think these are issues that I think have historically not been talked about, in things like infertility have been secrets, and, people have felt ashamed. And I think more and more and more people are feeling free to share their experiences and talk about it. And I think the more that it becomes just a thing that people talk about, and people around them realize that, oh, I'm not the only one, I think that also, I go back to, I think that creates a wave that will create a tipping point. The more people stop feeling shame about this kind of thing, because there's nothing to be ashamed about if you have fertility issues. And so I think just talking about it and then sharing your experiences and talking to people in power who can help push the law in the right way are the ways to help create change.
I think I can safely say that I and Fertility Matters feel the same way about that. So much of what we do is trying to destigmatize any fertility challenges, including third parties. So thank you. We don't have any more questions coming in, but is there any final thoughts you want to leave our viewers with?
No, I guess I just like to say thank you all for listening. I've had this has been fun. And like I said, it's my first Zoom meeting like this, so I hope it went well. And if any other questions do come in after or anything, feel free to shoot them to me, and I can try to provide like a response. I don't know how that would happen, but or to share my presentation.
If there are any additional questions, I can shoot you an email with what those questions are, and we can post the answers on this chain.
Okay, sounds good.
Okay, wonderful. Well, thank you so much, Michelle, for joining us. We really appreciate the time you took to talk with us about this incredibly important subject. As I said earlier, I think when we start talking about third-party anything, our community gets a little quiet, and we want to make sure that everyone who is seeking these as solutions to making the family the way they want it, have the information they need to be able to do so. So thank you so much for joining us today.
Thank you.